All right, very excited to talk about our managing attorney, Craig Hartsuyker, who many of you who are on the plaintiff side probably know his name as the lead partner of the Farmers Insurance Hartsuyker, Stratman, and Williams Abrego. But Craig, welcome. Tell us a little bit about you, and then we'll talk about what we do here.
Well, I spent many years on the defense side before coming over and working with Mike as regional head of claims litigation for farmers for years, managing all of California litigation. And we had thousands of litigated cases here in California. So I got a healthy dose of defense background and looking at cases, and now flipping that coin and working with Mike for the good of the office and for the good of our clients to make sure that they get fair value on their cases. So
what do you think from coming from an insurance and a higher up in an insurance law firm? What have you taken that you think applies well to you managing a plaintiff's firm?
So I think one of the key components, and you and I talk about this a lot, is, hey, what do we need to get the defense side? What do we need to get the insurance claims adjusters in order for them to be able to issue fair payment to our clients? And we often talk about, hey, we need to get them all the information. And I think that that's refreshing to hear when you come from the defense side. Oftentimes, a lot of plaintiffs' firms play hide the ball or are disorganized and don't get that information out. And it makes the litigation process difficult for both sides.
So let me ask you, I've talked about this as we're in an adversarial, what's the word I'm looking for? It's an adversarial system, but it's a collaborative process with the defense in that adversarial system. You'd agree with that?
I think that there's a lot of gray area in what the valuation of the cases are. And you and I talk about that gray area a lot. We differ in opinion about, hey, what is the value of a case? Oftentimes, we don't see a difference that there is value in a case. There is value for our client, and our client should be compensated. It's about what that value is. And that's a fair disagreement between plaintiff's counsel and defense counsel. And figuring out what that fair value is from either side is the adversarial part. The collaborative part really is, look, we both know we need to get information. We both know that we need to get that information to the insurance company in order for them to be able to issue payment. That collaboration, the more collaborative it is, the more efficient it is, the better it is for both sides. They don't want to spend a lot of money. We don't want to spend a lot of money to get our clients what they deserve.
So I've heard some plaintiffs' lawyers say, Mike, you look weak if you give up the information too easily, or if you don't fight to hold it back and make them fight for the information. When you're on the defense, do you think lawyers that willingly give information look weak?
No, and quite honestly, you know what? I think that one of the things that you've learned over the years is using those relationships. Those build the relationships with defense counsel or plaintiff counsel. And those relationships are what make a more collaborative process in order for us to all get where we need to get for our respective clients more easily. And if there's more professionalism in the bar in that regard, I think that we would be serving the entire industry better.
Yeah, and it's not just professionalism. I've talked about, and I want to confirm if this is right or wrong, that everybody has a boss, has a supervisor. I have a boss and a supervisor. She's downstairs, right? But you have adjusters and defense lawyers who have to report to somebody higher up. And if the plaintiff lawyer gives that adjuster or defense lawyer the information, the ammunition for them to look good, to check the boxes for their supervisor, is it easier then for that lawyer to get money to settle the case?
Not only is it easier for them, but keep in mind that most of the defense counsel are billing hours, right? If we can spoon feed them that information, they can regurgitate that to the insurance claims people, bill their hours for it still, do their analysis, but it makes it much easier for them to do that analysis rather than have to fight for every scrap of information and get it piecemeal. And that kind of adversarial system only creates animosity between defense counsel, insurance companies, and plaintiff's counsel.
So we were downstairs on one of our team meetings going through a team's caseload. And one of the questions I asked is, have we sent video and photos of what the plaintiff looks like even before the collision to the defense? Because I think that a carrier wants to know who they're dealing with. If the plaintiff is young, old, pretty, a family person, etc. Is that something that is important?
I think it's important, but maybe not for the reason you'd like to think. It's not about how big a heart they have, or hey, we really like this person. What they really want to know is how well the jury's going to like them.
And I agree with that.
Right. I'd love to think that insurance carriers and defense counsel really get to know the plaintiff on the other side and care about them. They're more pragmatic than that. There are, like I said, I had thousands of cases in litigation. It's hard to get too big a heart. When you're talking about thousands of litigated cases, and you see really catastrophic cases every single day, you get a little calloused. But from a more pragmatic view, they do want to know, hey, how's that going to affect the value of the case? How's that going to affect how a jury's going to see it? And from that standpoint, it can, in that gray area we always talk about, right? That can move it to the higher end of the gray area, and that's our job. That's what we need to do, is make sure that, hey, we're not trying to get unfair value on the case. We're just trying to make sure that everybody understands what the full value of the case is.
So that question, how does the plaintiff present? How do you think the plaintiff is going to present at trial, especially if you have, an active, attractive, family, positive, vibrant plaintiff that you have videos and photos of? That's something we want to give to the defense, not to make them like the plaintiff, but really to say, this is what this person's going to look like in front of a jury.
Yeah. And I think that on the defense side, though, too, they want to make sure that they've fully evaluated their case, and that's a factor. So anytime we're on the plaintiff side, giving the defense side the full picture, whether that's all the medical records, whether that's, hey, this is who our client is, and this is how our client's going to present to a jury, painting as full a picture as we possibly can to give the defense side all the information in order to evaluate their case fairly, that's the adversarial part of the system. We're just trying to make sure that they've got the complete picture on their side, just as we do. And that requires us to go get that information and make sure that we've taken the time to understand that from our perspective as well.
Yeah. All right. Sounds good. And so now you've made the jump, and now you run AlderLaw. And how do you feel like you're using your vast defense knowledge and how to organize and the insurance practices? Yeah. How are we using it here at the firm?
So, you know what? One of the privileges, and when you and I first started talking about endeavoring on this together, is that as we look at cases, we have a lot of flexibility. We get a lot of cases in every month. We get a lot of cases that people come to us for help on, and some of them we decline. Some of them we decline because they're not who we want to be. We want to have viable cases that are, really where we're in a position to help people.
Right.
And where we look at a case and we don't think we can do that, or we look at a case and we don't believe in it, we have a lot of flexibility to not take that case because of the amount of cases that we see every day. So I really enjoy that aspect. If I were at a firm on the plaintiff side where, I was having to take every case that came in the door and there was no discretion to take the cases only we believed in, I would not be happy.
Yeah.
And that's really one of the things you and I talked about at the outset is, hey, look, we're not in a position that we have to take every case that comes in the door. Let's take the ones that we believe in.
But as you found out in the plaintiff's practice, everything has a balance. And so, as you said, well, this isn't really a great case, but if it's from someone we have a relationship with, if it's somebody I've known for a long time, if it's somebody that we're trying to help out, if we're going to do maybe it pro bono, or we're going to try to just make it happen. There are some of those cases.
For sure.
And I know you're like, let's limit how many of those are taken.
I want to limit those from a business perspective, but believing in a case, there's a lot of factors that come into believing in a case. Maybe it's we believe in our co-counsel. Maybe it's we believe in, like, this is a smaller case, but we believe in the person, right? We have a relationship with a prior client. So there's a lot of factors that come into kind of believing in a case. I'm not saying that every case, and sometimes, frankly, look, a case doesn't turn out to be what we think it was, right? We still have a duty to, make sure we represent that client, represent them well, and bring that case to fair value, right? So we will do that. We'll continue to do that. I'm not perfect in evaluating cases when they come in the office. I try my best, but there are a lot of factors involved in that. But my point is that we do have the discretion to do that. We do have the discretion to make the best decisions we can to take the cases that we believe in most. Whatever the belief is, whether it's co-counsel or the client, or, hey, we're trying to do the right thing for this particular person.
And, I make jokes all the time that I would kick you off of a jury that I was impaneling. You would kick me off a jury that you were impaneling, at least when you were on the defense.
And that's part of the process. So that's a beautiful thing in the practice of law, that we can disagree. You and I can disagree, but still respect each other and still work together in a very collegial way.
I agree. And one of the things that I think is so beneficial about us now working together is what we did this morning, what we're going to do this afternoon, what we did yesterday and the day before, meeting together with teams, lawyers and the staff, to go through their cases, what they're doing, how do we prove liability, causation, damages, what evidence do we have, what evidence do we need, how is that admissible, what's the value, what do we need to provide to the other side. And many times I have a thing, you have a different thought. We certainly don't always agree on value, but it's very helpful for you to come in from having seen what the back room thought process is of a carrier. Hey, you're going to need to give them 2 months to digest that before. And we've adjusted some of the way we've done things.
Yeah, and I think that one of the beauties about practicing law is when you can have that robust argument, in front of other lawyers, and give them permission to really think through those strategies and start to, hey, it's okay. They don't need to agree with us all the time. Let's have the conversation if you have a different thought, and we'll get to a better place by having that diverse thought process.
I totally agree. So I think that's good. Is there any things that you feel like, again, there's no set topic or anything that,
what I will say, Mike, is we should start to script certain topics. I think that you and I having this conversation, and like I was talking about the robust disagreement, if we can start to have that, people enjoy hearing the back and forth, right? People enjoy hearing about especially you and I have a really, really good rapport, to hear that it's not about the disagreement, the rapport, having a great rapport with each other and disagreeing at the same time. That's what, that if this was the defense counsel, plaintiff's counsel, out in the world, we would be in a much better place, because we could have disagreement and really figure out what the issue is, what we're disagreeing about, and bring that to a point.
I agree.
I think too often people just disagree and don't provide the...
Well, how many times when we're in these team meetings and I would ask, well, have we called the defense lawyer? Have we emailed the defense lawyer, texted them? Well, not yet. And I'll do it right then. And before we're done with the meeting,
you'll get a response.
The defense lawyer's like, hey, man, I'm so glad you reached out. All I need is X, and then we can... And that, before email, before, that, when we were practicing in the 90s and certainly the early to mid 90s, I mean, that's what you did, right? And then once email started, and then now, a new generation, that's kind of a lost art.
It is. And teaching that, having everybody else see you do it, what the next step to that is that it's not about Mike Alder. It's, hey, what Mike does, you can do too.
Right.
You can develop those same relationships. You can develop and have those same communications. It doesn't have to be you. It's just that, you've taken the time over the years to foster those relationships, to create that rapport with defense counsel. And so when you reach out to them, they're willing to hear you.
Which is why you do be respectful, which is why you are civil, right? It doesn't mean that you're weak, right? We don't agree to trial continuances, period, unless it is a defense attorney's health or family vacation. And we're very upfront when they're like, hey, let's move the trial. And I'm like, we're not going to do that unless you're telling me that you've got a health issue or you need a family issue. And if they do say that, then we will move the trial. But people are like, oh, you look like a jerk. You won't move trial dates. I'm like, no. I do it in a very civil way. And people respect that. That's why I write notes after every case that we resolve. And people respect that. And then it comes around the next case. Do lawyers, when you were at Farmers, did the lawyers talk about plaintiffs' lawyers?
Yes, but not as many as you might think. There was, there tended to be a list of, 5 or 6 plaintiffs' lawyers that everybody was like, okay, if this is who you see, and you were one of them, obviously, because I was well aware who you were before you and I started working together. There's a few that everybody's like, okay, look, flag this one,
As they're good lawyers, good firms.
They're good lawyers, they're good firms, they're problematic for whatever reason on the defense side.
And mediators have told me that, hey, I'm going to go get you the Alder bump, the Dordic bump, the Panish bump. And I think that's, that applies. But also, when you were at Farmers, did you talk about the firms that you can't trust, that you got to watch out for?
There were fewer of those, and the reason being is that those firms, though, might have been a pain in the ass, but they weren't problematic in trial. Those firms tended to fold because they didn't do their job well.
Because leopards don't change their spots.
Yeah. So either, they were just a pain in the ass for being a pain in the ass, in which case, okay, we can deal with that, right? We've got plenty of resources. We'll just keep handling the cases the way we do. And you know what? But, one of the things you were talking about earlier downstairs, we were talking about, trial continuances, and on the defense side, we didn't like to continue trials either, which I found ironic, right? Like, oh, hey, I wish I would have run into Mike's office more often, because on the defense side, from a higher up perspective, we want to move files, right? The actual defense lawyer might be more inclined to, want to continue the trial because they don't want to do the work, or, they've got a lot on their inventory. But from a higher up perspective, because we have so many files, and the more files you have, the more cost you have on litigation, we need to move those files out from a higher up perspective, right? On the actual, handling the files, that's difficult when you're the defense lawyer. But, from a bigger picture perspective, we've got to move those files and get them completed in order to be financially responsible.
Let's talk about that, because I think if you can share that, that's very helpful. Can you explain the process from an in-house counsel perspective?
Yeah.
Of a lawyer, they want to move files. Carriers, they want to clear out their reserves. They, if they don't settle so many cases or get them, they're going to get overwhelmed. What are the general parameters for?
So one of the parameters that carriers look at, and I don't particularly love to talk about farmers specifically, but I will give you my experience, and it's predominantly farmers. But so the closing files, you've got to close files, because the more files you have open, the more attorneys you'll need, the more staff you'll need, the more expensive the entire process is, from experts all the way down to, the office space you used to need before COVID, at least. All of those factors are overhead for a carrier, and they're, tens of millions of dollars a year, hundreds of millions, oftentimes. So the more cases you carry an inventory, you build up an inventory, the more people you need, the more space you need, the higher your litigation costs. And you know what? Yeah, do they want to pay the right amount? Sure, they want to pay the right amount, but you want to pay it as quickly as you can, right? So bringing that issue to its conclusion, getting the information from plaintiff's counsel and getting the case closed is a huge factor in running a fiscally responsible operation on the legal side.
Then why are we seeing so many requests to continue trial from defense firms?
So I think that it depends on which defense firms you're seeing it from. It always surprises me when you're getting a lot of those from house counsel, but those attorneys often have a big inventory, and so they get behind on cases, right? And the attorneys are then, they don't want to go to trial and ultimately, be accountable for a trial verdict, because that's a closed case that's settled, they
got no skin in that game.
They got no skin in that game, right? It wasn't
the claims within the policy, move on.
Right. The claims department made that decision, wasn't the attorney. If it goes to trial, all types of people start to look at it, second guess, did the attorney do everything right in the whole life of a file? And rarely is that the case. I mean, you've litigated lots of cases just like I have, and rarely do you litigate a case from beginning all the way through trial perfectly. That's not the nature of what we do. It's the practice of law. You're always practicing, right?
Right.
So to have, insurance executives then second guess you as the trial lawyer, that's not pleasant. That's not fun.
Non-lawyers second guessing lawyers.
Exactly
yes.
Right. So that process is not for the faint of heart.
And is that the same if with outside counsel that the case had been in-house?
Yeah.
And then for whatever reason, new counsel, above policy demand, whatever it is, it gets sent out to outside counsel.
In some respects, with outside counsel, it's even worse, because their livelihood depends on the carrier continuing to send them business. So if they're perceived as having made a mistake in trial, they lose business, and they could lose an entire carrier's business for the entire firm. So that's why oftentimes you see with panel counsel, only a few select attorneys ever trying cases. They're the attorneys that have built up their reputation, and are kind of bulletproof with carriers. And it's very difficult for younger associates to break into the trial business, because nobody wants to take a risk on being second guessed with letting an associate try a case. And then if something goes wrong, they're going to lose their business.
And I love the fact that one of the lawyers in Farmers that had that street cred, Daniel Cruid, is now a trial lawyer here at AlderLaw.
Yeah.
And he certainly does have that street cred. And it was interesting, at the recent CALA convention, I talked to a couple lawyers on the plaintiff side who have tried cases against Daniel when he was at Farmers. Did not get great results. One got defensed on a very significant case and had nothing but great things to say about Daniel, about his professionalism and about his skill level. And he's been with us for, a month?
Yeah.
And I'm like, yeah, this guy knows his stuff, right?
Yeah, and I heard him and Dustin talking earlier today, and the shop talk between the two of them, you want to start to hear that more, right? I'd love to get those two in a room with you, talking with the other lawyers in the office to continue that, that momentum about what we got. And one of the reasons why Daniel came aboard with us is because obviously some of the relationships that me and Lucy, who's joined us as well, have developed over the years, and lawyers that really want to be trial lawyers and really practice their profession. I like to think they'd like to work with us.
And as a part two, this is a lead-in, the in-house Farmers, Hartsuyker, Stratman, and Williams Abrego. Hartsuyker's here, and Williams Abrego is running our workers' comp firm. And the two of you really had that great relationship with Daniel, and were able to convince him to finally jump to the side of good. And he's he was set to try a case on Monday. So
I think he's still going to go out Monday.
Yeah, all good. All right. I think this is great.
Okay, great.
Thank you very much.